You said during your testimony that you didn't know if you needed a court order to seize the bank accounts as freeze assets. Is there a reason why you weren't aware that you needed a court order to do that?
No, the seizing, I knew that you needed a court order. I wasn't sure on the freezing because we've never done the freezing of accounts. Obviously, when we seize accounts, that's a different aspect, but the freezing was pretty new to me and I haven't looked at it any further.
I'm heading out on this traveler's road, and I won't find peace till the day we rest in harmony. Tell me what's so wrong if I choose to disagree. We're taking Highway 1 till we're living free. Fighting till we're living free. Oh, standing in unity.
We knew full well that there needed to be a public inquiry. Canadians need that level of transparency and accountability.
Prime Minister Justin Trudeau is expected to testify at the Emergencies Act inquiry later this week. This is the final week of hearings. Emergency Preparedness Minister Bill Blair, Public Safety Minister Marco Mendicino, Defence Minister Anita Anand, and Deputy Prime Minister Chrystia Freeland are also among the Liberal ministers added to the witness list.
I was becoming increasingly alarmed listening to my Prime Minister call me a racist and say that I shouldn't be tolerated. I found his rhetoric to be incredibly divisive, and I'm a believer that if you are a leader of a country, you have to lead all of your people, even if you don't agree with them. And I just saw so much. Coming across Canada every day, I heard stories. People, at least 3 people, would tell me they were planning their suicides until we started the convoy. Or stories of people that we were too late. I heard from families that were living in their vehicles because they'd lost their jobs. I heard from people that had lost their jobs and lost everything. I have the tears of thousands of Canadians on my shoulder who every day told me that we were bringing them hope. I saw little old ladies praying on their knees on the side of the road, and I saw little children holding signs saying, "Thank you for giving me back my future."
The federal government has invoked the Emergencies Act to supplement provincial and territorial capacity to address the blockades and occupations. I want to be very clear. The scope of these measures will be time-limited, geographically targeted, as well as reasonable and proportionate. We're entering the 3rd week of illegal blockades that have been disrupting the lives of too many Canadians.
It's my belief that the police will move tonight or sometime in the early morning and start rounding up peaceful protesters. Should that happen, my concern, truthfully, is that it escalates the situation on the ground, making it more tense, making it dangerous for everybody. And I want to be clear about something. We start off every meeting that we have with a prayer. And in every single meeting, we talk about safety and responsibility. Not just the safety of the truckers, but the safety of the law enforcement, of the citizens of Ottawa, everybody who is here. We constantly ensure that we can be as safe as possible. And we're trying to be responsible with every decision that we make. Our beef is not with the City of Ottawa. It's with the federal government in their mandates.
We've already heard from every law enforcement official, as well as we have these statements from CSIS and evidence, that they didn't have reasonable suspicion that any of this was taking place. So I take it that you can agree with me that you didn't have any evidence with you before Cabinet or even considered of any espionage or sabotage against Canada that is detrimental to the interests of Canada or activities directed towards or in support of such espionage or sabotage, right?
That's been discussed, yes.
Right, and so that, there was no evidence of that you considered in your assessment. And you could agree with me that there's no evidence of foreign influenced activities within or related to Canada that are detrimental to the interests of Canada, are clandestine or deceptive, or involve a threat to any person, correct?
There were threats to people.
Right, by email and Twitter, right?
I would submit that in the social media era, you cannot ignore threats against officials and public office holders just because they are on social media. That would be inexcusably negligent.
Right, but that's up to the police to deal with, or is that a national emergency?
Jody Thomas's role is the national security advisor to the Prime Minister. And I still have a tough time understanding why on earth the Prime Minister has his own national security advisor when there's a whole department and there's a minister in charge of public safety, and then there's another one for emergency preparedness.
It was supposed to result out of 9/11. That is what created the position, the reason for it. But with respect to Ms. Thomas, and great respect to her, she had basically no background in national security and intelligence. I don't understand why your national security and intelligence advisor would not be a foremost expert on national security and intelligence, given that's what they're advising on. And it's an interesting position that is not actually a requirement at law.
She then floated out this new thing that started to come from all the witnesses after.
So you're saying that the CSIS Act and Section 2 of the CSIS Act, which is incorporated into the Emergencies Act, means something different when you're looking at it?
No, that's not what I've said.
So what do you mean?
I mean that in terms of the Emergency Act, the Governor and Council can consider more broadly than the intelligence collected by CSIS in determining a national security threat or situation or a public order emergency.
I understand that, but you do agree that the 4 grounds of types of threats in Section 2 of the CSIS Act are what is in fact required to have been found.
No, I don't agree.
So it can go beyond what the Act says, which is a threat to the security of Canada.
There are other definitions of threats to the security of Canada, as we saw earlier.
Right, but not in the legislation.
The Emergency Act allows for the Governor and Council to make a broad decision about public order emergencies.
That's not what it says, but you can agree with me.
I think that this is an argument to have with lawyers.
When you ask me about what is the importance of her testimony, in my view, the importance of it is that it demonstrates that the invocation was political.
In the context of the Emergencies Act, there was to be a separate interpretation based on the confines of that act, and that was, instrumental. Starting on the 10th, I believe, when we discussed that, to make sure that we understand, and how we would be not informing, but, using the words very carefully and very much specified, when we were providing advice and information, it was based on the CSIS Act definition.
Oh, but you interpret Section 2 differently of the CSIS Act when you're looking at it through the lens of the Emergencies Act. If in first-year law school you learn about statutory interpretation, if there was a law school question that said, do you interpret Section 2 differently of the CSIS Act when you're considering applying it under the Emergencies Act, and you wrote as a law student, yes, you interpret it differently, you would get an F.
In my view, it was an ex post facto idea, and the fact that they said, well, you'll hear about it in argument. Well, that makes no sense, especially at a public commission, where the purpose of it is to be transparent and everything. There was nothing in the record discussing at all in any of the records disclosed about this broader definition.
Did you see any documents that talked about this interpretation that you're discussing that existed prior to the invocation of the Emergencies Act?
Again, I'm going to rely on solicitor-client privilege there.
He kept invoking solicitor-client privilege. And if the Prime Minister wanted transparency, if the Cabinet wanted transparency like they alleged they did, which they clearly did not by their actions, they could have told Lametti, here's your waiver, here's the scope of it. It starts on this date, ends on that date. That's what mine says. I can talk about events from this date to that date, this range of subject matter, and I can talk about them in this setting. They could have easily done that. They didn't. There was no desire for transparency. It was obfuscate, conceal, distract.
Our next and final witness is Prime Minister Justin Trudeau.
Please scroll down. The rest of this document has been redacted. So that's page 4, page 5, page 6, page 7, page 8. So Prime Minister, you said we should read this plan. We can't.
Can you identify on the other side what information was blacked out as irrelevant by your government?
Americans offering tow trucks.
Yeah, and wouldn't you say that discussion of tow trucks was relevant to the discussion we're having here today?
I'm not the one who made these redactions.
Because I have to build a record for this. Do you have any idea why anything in your conversation on February 4th in that note would be irrelevant?
I don't know.
If I told you that there is a whole bunch of unlawfully redacted documents that we've been fighting over and waiting for an order just to get them today, and we haven't had them for this whole proceeding, do you think that's transparent? No authority for redacting documents on the basis of a parliamentary privilege. So I'm wondering if under your powers, under Section 5 sub D of the Department of Justice Act, if you can direct that the Department of Justice release all the records that they've provided in this proceeding with the redactions for parliamentary privilege unredacted.
Mr. Commissioner, I don't think that's an appropriate question. It doesn't suit the purposes, fall within the purposes for which Minister Lametti is here.
And not only did Justice Rouleau say this was a truth-seeking process, but he said that Canadians ought to have answers. And if he thinks that's sufficient for Canadians, that's what he believes. I don't believe that's the case.
So there was two issues that we had problem with transparency in the federal government. The first was the late filing of documents, and the second was the extent to which they were heavily redacted. So it became more and more problematic as time went on because Brendan Miller and our legal team had assessed that these were not proper redactions. For example, there would be communications between staffers, neither of whom were a lawyer, not involving a lawyer, and they claimed solicitor-client privilege. Well, no, that's a communication between a solicitor and a client, a lawyer and a client. As time went on, we made motions, formal written motions in accordance with the Commission's rules, and things escalated.
Sir, okay, the Commission Counsel has not completed her
I understand that, sir, and your counsel's advised you that.
No,
I know you've directed, you wanted the application.
I'm speaking.
Yes, sir.
The application, if you want to do it, you've been advised it's to be done in writing, not in the middle of the presentation.
Sir, we filed 2 motions in writing at your direction that you've refused to rule on with respect to the redaction of documents from the Government of Canada.
You're speaking,
that has not been ruled on, and they've been filed for days.
I will take a break while you're asked to leave. I will return in 5 minutes if security could deal with the council.
And it was discussed that there was a chance that I was going to be tossed if we press this further, but we went on. And so I approached the podium and said, I'm going to deal with this. They originally, his counsel says, no, we want you to do it in writing. I'm like, well, I've done that 3 times now and you're not doing anything. So I'm putting this on the record.
Canadians are entitled to the truth, and you can't hide behind unlawful redactions in public inquiry, claiming baseless redactions on staff or correspondence because it may hurt you.
In my view, the Commission just didn't want it on the record.
The redactions were outrageous. 2 days before they testify, we had to list all of the documents from the record that we were going to potentially put to them in cross. So they knew every document that they were going to be asked about so they could be prepped on it ahead of time, and the topics we were going to put to them. And we'd request an hour and a half. We'd end up getting 15 minutes. That was it. Or 10 minutes, sometimes 20, but never more than 20. And then some witnesses, like Deputy Prime Minister Freeland, were masters at running the clock.
If the direction of the question is to suggest that the COVID vaccines are more dangerous in some way than previous vaccines we've used in Canada, I'll say, one, I'm not a health expert, but I believe very much in really the advice, the effectiveness, the thoroughness of Health Canada.
Okay.
They're very good at judging the safety of vaccines. And I will say, I have been vaccinated 4 times. My children have been
understand, ma'am. I don't need to know that. But
it does speak to my confidence in the vaccines. If I've had my children vaccinated, it speaks to my belief that they're safe.
Please stop talking out the clock and let me ask my questions, okay?
I guess what's important from some of the evidence is how many calls and advice she was getting from people that weren't her ministers, that weren't the cabinet. She was getting calls from investors from the United States, I think, or bank CEOs. Why do they have a private line to the Deputy Minister of Canada? And is that appropriate, especially in a situation of national security threat?
Agree with my colleagues. The reputation of Canada is at risk. Just spent a lot of time in the US last week, and we were being called a quote unquote joke by people. I had one investor say, I won't invest another red cent in your banana republic in Canada. That adds to an already tough investment perspective on Canada. Did that have any impact on the banana republic idea? I mean, it's hyperbolic.
Well, yeah, so with the Banana Republic, that is, again, going back to the discussion from week 1, is mismanagement and, frankly, incompetence of our governments and police authorities to manage a situation, or mismanaging it by using an old playbook.
Is Tamara Lich a terrorist?
In terms of designating who is a terrorist and who isn't, that is not my job as Minister of Finance or Deputy Prime Minister.
Okay.
We have authorities whose job is to do that.
Right. And so it's not your authority to designate Tamara Lich, Chris Barber, Tom Marazzo, or Danny Boldford terrorists. That's somebody else has to do that.
Yes, we have intelligence services, we have enforcement agencies whose job is to determine who is a terrorist.
Okay. And there you say that you need to designate the group as terrorists. So, but it's not your job, but you wanted to designate them as terrorists, right?
So that handwritten note in my notebook. I can assure you that was not a meeting with the director of CSIS, with whom I didn't have a meeting.
It says, it's with David Vigneault from CSIS.
It doesn't say that. It says it's with a gentleman called Dave.
Which Dave?
That meeting, that is not an account of a meeting with Dave Vigneault, because I didn't have a meeting
which Dave is in
with
those
the
notes,
CSIS director.
Which Dave is in those notes? What's Dave's last name?
I need to see my whole notebook that you're referring to, but I can tell you for certain.
It only says Dave.
Who else would you tell to designate someone a bunch of terrorists? And if you were to tell someone named Dave, that wasn't Dave Vigneault, to designate someone terrorists, and it was as important enough to write it down in your personal notebook, one would think you'd remember who that Dave is.
Sorry, that threat that you're speaking about is with respect to individuals, but the protest itself did not pose a Section 2 threat to the security of Canada.
What we've testified to is that we did not make a determination that the event itself, and I think it's part of our testimony, yes.
Okay, and yet you still advised the Prime Minister to invoke the Emergencies Act?
Yes, I did.
You know, all I can say is that makes no sense. You're supposed to be a professional. You know how to read the law. That makes no sense whatsoever. You're covering for the politicians, and, you know, write that guy's name down, follow him. I bet you in future years you will find out that he's the new ambassador to France or to Switzerland, or, you know, better yet, the ambassador for Canada to Barbados.
So you'll see that this note, it's the notes from Ms. Jackson. It says February 4th, KT call. So I'm sure you can agree with me that KT, that's Katie Telford, is that correct?
I have no idea, sir.
Okay, so let's scroll down to page 4, please. And there at the note on February 4th, 2022, it says Blair Strategy Emergency Act. You see that?
Yes, sir, I see it.
Yeah, because it was your strategy on February 4th, 2022 to get the Emergencies Act invoked, was it not?
No, sir, that's incorrect.
So why would, in a conversation, to your knowledge, why would Ms. Jackson record that in a meeting with Ms. Telford? Why would she do that, to your knowledge?
I have no idea, sir.
It was remarkable how early on the government was actively contemplating it, instead of sitting and talking down with the protesters.
Emails from January 27, 2022 at 4:21 p.m. You can agree with me that the protesters in Ottawa didn't arrive here until the 28th. Is that fair?
That's my understanding, yes, sir.
All right. So they're already preparing the narrative that they're going to label the protesters with. Can you scroll down, please? And there I put this to the last witness as well. Our government recognizes and respects that everyone in Canada has the right to safe and peaceful protest. Threatening acts of violence and inciting hatred, as we have seen from a select few in recent days, is unacceptable and does not reflect the views of the majority of Canadians. We condemn all such hateful and violent rhetoric in strongest terms. So, can you agree with me that that labeling of the protesters had already been set out on January 27th?
After January 31st, with the Prime Minister going on live television and saying what he said, they put themselves in a bind.
In this email, and again, it's January 27th, 2022 at 4:21 p.m., you're aware that the protesters in Ottawa hadn't really even arrived at that time, right?
The second or third day of the protest, and your mind goes straight to the Emergencies Act in the first text we get produced in these proceedings. Can you explain why that came so quickly to your mind?
I was being prudent.
Well, on February 4th of 2022, Ms. Jackson, in a conversation with you, writes down Blair's current strategy, Emergencies Act, right? And you hadn't even had an IRG at that point.
I believe you've had an opportunity to speak with Minister Blair.
Yeah, and I put this to him, and he said that it wasn't true.
It doesn't surprise me that the evidence was they were trying to vilify and create this narrative of extremism on the protesters, the Canadians who went to Ottawa before they even got there. or that they were actively talking about the Emergencies Act, the biggest, most oppressive club that the government has in its war cabinet that they could use.
You can protest. You can share your opinion at the top of your lungs. You can disagree with elected officials. You can certainly disagree with me. But you can't harass your fellow citizens who disagree with you.
Farouchement opposés à la vaccination.
Qui sont extrémistes.
Qui ne croient pas dans la science, qui sont souvent misogynes, souvent racistes aussi. C'est un petit groupe, mais qui prend de la place. Et là, il faut faire un choix en tant que leader, en tant que pays. Est-ce qu'on tolère ces gens-là ou est-ce qu'on dit, ben voyons, la plupart des gens, presque 80% des Québécois ont fait ce qu'il fallait faire, se sont fait vacciner, on veut revenir aux choses qu'on aime faire.
Et small fringe minority of people who are on their way to Ottawa or who are holding unacceptable views.
Folks out there tonight shouting, the anti-vaxxers, they're wrong. And those people are putting us all at risk. Aaron O'Toole deciding with them, I am not going to back down no matter how many of them show up to try and shout us down from what I know to be true, what science tells us, what Canadians have told me.
Now is the time to work together. Look, in the heat of the moment, we can all get carried away trying to win an argument. But not every single conversation has to be about winning an argument. Sometimes it's more important to just be there for one another.
Will have testified in this inquiry referencing your widely published comments and calling the unvaccinated racists and misogynists. And we have heard testimony in this inquiry about how some of your officials wanted to label protesters as terrorists. Would you agree with me that one of the most important roles of a Prime Minister is to unite Canadians and not divide them by engaging in name-calling?
I did not call people who were unvaccinated names. I highlighted there is a difference between people who are hesitant to get vaccinated for any range of reasons and people who deliberately spread misinformation that puts at risk the life and health of their fellow Canadians. My focus every step of the way, and the primary responsibility of a Prime Minister, is to keep Canadians safe and alive.
Well, I don't know if it was lucky, but I was very humbled to be able to speak on behalf of literally millions of Canadians that felt that they weren't heard by the federal government. For years, families were broken. There was so much mistrust by Canadians, and they wanted to be heard and they wanted answers from the federal government and Prime Minister Trudeau. He vilified a huge segment of Canadians. He called them names, and it's not something I would ever expect a leader to do. A leader is meant to unite people, and I was very humbled to be able to put those questions to the Prime Minister of Canada on behalf of millions of Canadians.
My last question, Mr. Prime Minister, when did you and your government start to become so afraid of your own citizens?
That's a very
unfair.
I am not, and we are not.
Those are my questions.
In the final week of the commission, the policy phase took place. Independent third parties, which specialize in all manner of law, media, and policing, provided their suggestions to the commission on what should come next, and more importantly, how the Emergencies Act could or should be amended.
It makes no sense, in my view, to tie the Emergencies Act to a definition within the CSIS legislation. I don't think it works. I don't think it's effective, and certainly if there was a decision, you were to come to the conclusion that the definition is insufficient and it should be changed, to try and change that definition within the CSIS Act to allow you to broaden the definition for the Emergencies Act, I think would be a mistake.
The definition there is one that is routinely applied, understood, and subject to lots of review, as we've heard. And the whole point of including it in the EA was to eliminate questions about what does and does not amount to a national security threat that could trigger the EA. And I'm talking about threats from terrorism, subversion, espionage, etc.
As we record this, there has yet to be a decision rendered by the Commission on whether the invocation of the Emergencies Act was justified. As a viewer, just having witnessed many important details of the Commission and what transpired, it's our sincerest hope that you are able to make that decision for yourself. The infamous legal opinion that was provided to Justin Trudeau's federal cabinet, prepared by their own Minister of Justice, David Lametti, was submitted to the Commission as a public document. However, like so many documents submitted by the federal government to the Commission, it was heavily redacted. Canadians may never know what happened behind closed doors to result in a wartime law being invoked on peaceful political dissidents in their nation's capital.
After careful consideration, we're ready to confirm that the situation is no longer an emergency. Therefore, the federal government will be ending the use of the Emergencies Act.
What happens next may be far more infuriating than the initial process itself. If the Commission rules the invocation was justified, the Trudeau government will have gotten away with the single largest violation of Canadians' civil liberties in modern history. Trudeau will, again, skirt responsibility for imposing a form of martial law, freezing assets, and imprisoning those who chose to disagree and to express their disagreement in the nation's public square. Justin Trudeau's government added sanctions and censors to our words and opinions so that there could be no legal recourse if we objected. If the Commission rules the invocation of the Act was justified, it will add another item on Trudeau's long list of ethics violations. However, the only punishment will be yet another scolding in the House of Commons, which will mean nothing more than a viral video for the same politicians who never met with the protesters in the first place. Beyond these two outcomes, suggestions will be made on how to amend the Emergencies Act, to normalize its invocation, and to make it easier to use at the whims of sensitive cowards one more time. But within this last option lies a scarier, more nefarious scenario to be considered. Will the Liberals commit to defining that online rhetoric now constitutes a threat to our national security as well? Will it once again be left to politicians to decide what constitutes a national security threat over the advice of law enforcement? Will these same politicians do this again to the Canadian public without consultation from the premiers, members of parliament, or even their own citizens? Nothing stopped them the first time. If the law can't help us, then what can?
But using protests to demand changes to public policy is something that I think is worrisome.
I'm heading out on this traveler's road, leaving all behind to revive my soul. And I won't find peace till the day we rest in harmony. They tell me I'm the one to blame, so they cast their stones and put me to shame. Damn your lies, you are a master in disguise. Tell me what's so wrong if I choose to disagree. We're taking high what you want. I'm not what you believe. I'm just a simple